hearing tonight.
All right, we'll try to see if you can get on in the next 10 minutes or so. Thank you, Mia. You are free to go.
Thank you, Your Honor.
Well, observers, I guess you.
Yes, Your Honor. Unfortunately, the parties on position 6 were not able to come to an agreement.
That doesn't surprise me. They're family. It's all good. I'm gonna hear it from everybody. We'll figure out what's going on. Do we need you for anybody else?
Not if there are no other cases, Your Honor. No, sir.
I don't think so. So I will, because again, position 2, 3 is getting reset. 2 is getting reset. 3 was a debug. That was dismissed. That was a consent. All right, well, you guys are my only trial. Now listen, thank you, Mia. You are free to go.
Thank you, Your Honor.
Well, observers, I guess you get to observe a trial. So this is what we're going to do. I'm going to have everybody individually. Mr. Costin, give me 1 second. I'm going to give you that reset date. I'm going to have everybody clearly identify themselves who are here. And then I'm going to ask some questions from the plaintiff, and then I'll ask some questions for the defendant. I just want to be clear, by going forward today, you are consenting to having a trial via Zoom. And I'm going to get everybody's consent as we move forward. But before I do, I just want to see if I can get Mr. Kasim out here. Clerk, have you had any information on a new date?
Unfortunately, Judge Davis, even for your calendar, it's up to the max.
You can't put on it. Well, I don't know, put on anybody else. Mr. Kasim, let me just tell you, let me ask you a question. Can you unmute yourself? Unmute yourself.
Okay, go ahead.
All right, so this is the thing. As I explained to you, the defendant clearly has tried to get on via Zoom. They have been unable to get on via Zoom. That is clearly a technical issue, which generally would justify a reset because they breached out. Now, that reset can't be done until the 21st. And as much as that pains me, because I understand that I want resolution for all parties involved, based upon scheduling, that is the only thing that we have. I want to let you know that if she didn't show, I would have been happy to give you what you asked for, but she showed. And so as a result, we're going to be resetting the matter because we can't reset it any sooner until the 21st of March. You're going to get the new notice. If she's not here on that date, then we'll obviously address that fact, but she'll have more than enough time to make sure she can access Zoom and know how to work it. All right? So if she's not there on the 21st, we're just going to move along. All right?
Thank you, Your Honor.
No, thank you for your patience, and I'm going to let you go. You'll get the new notice.
Bye.
Bye-bye. All right. Reset. All right, folks, let's start with the plaintiff, Mr. Young, T. Young. Unmute yourself. All right.
Can you hear me there?
Not you, that's S. Young. I'm looking for All right. Mr. Tommy Young here. I want just to get your oral confirmation that you understand that you're proceeding today virtually via Zoom, and we'll be having a trial via Zoom. I will be able to look at evidence that has been submitted and uploaded to our court system. Do you consent to such, sir?
Yes, sir.
All right, excellent. All right, I'm now going to start with Mr. S. Young. Can you unmute yourself? Press that microphone button. All right. I just need you to unmute, sir.
Okay.
All right, Mr. Young, I just want to confirm that you are consenting to moving forward to having this trial via Zoom virtually.
Yes, sir.
All right, excellent. How about you? I believe this is D. Young.
Yeah, supposedly I'm here.
Okay, supposedly, sir. What is your real name?
Dunquavius Lee.
Spell Don Quavius for me.
D-O-N QUA, V as in Victor, IOUS.
Donquavius Young, correct?
No, Dunquavius Lee. See, he
Ah,
doesn't.
all right, it's all right. So we'll get there. Don't worry. Just Donquavius Lee. Check.
Yes, sir.
All right, and I just need your confirmation, in assent that we're going to be performing this trial over Zoom and virtually.
And virtually. So that is there an option to perform it in the courtroom?
There's an option, but it'll be quite some time, and you might very well have to pay into the registry of the court until that time. So your delay isn't necessarily going to give you any significant benefit. But hey,
I'm not asking for the benefit. I thought the benefit would be more likely if we was in the courtroom actually until the presence. You know what I'm saying? Presenting the evidence or whatnot.
well, this wouldn't be a jury trial. This would be a bench trial.
A bench trial. Okay, you can yeah, I consent.
All right. And ma'am, I see. I forgot how to pronounce your last name. How do we pronounce your last name, Laura? You're on mute at the moment.
My name is Evelyn Harvard, Judge, not
Evelyn?
Laura Shihab.
Evelyn.
Harvard,
Okay, spell that for me.
HARVARD.
No, spell Evelyn. Spell Evelyn. I'm sorry.
Evelyn, EVLY.
Didn't know. Spell a different way.
It's Evelyn, I'm sorry. EVELYN.
Okay, got it. All right. Okay. And do you consent to performing this hearing virtually over Zoom?
Right now?
Right now?
Yes, sir. I'm willing.
All right, bear with me. Hold tight. I'm going to get everybody under oath shortly. Hold tight. Just pull up the case. All right. I'm going to get everybody under oath, but I vaguely recall this after looking at everything. So, everyone involved, unmute. I see a witness here. Normally, who's W6?
Lavorn Young, LEVORN, YOUNG.
Are you a witness, or you think that or do you live in the property?
I'm just a witness, sir.
Okay.
I'm a sibling with some input. That's it.
All right. Well, hold tight. You can be on mute. Okay. D Young, everybody unmute, other than WY6 and the observers. All right. S Young, unmute. Everybody under oath. Can I get you to raise your right hand? So that means Mr. Lee, Miss Harper, Mr. S. Young, Sidney Young, everybody. Raise your right hand, Mr. Young. Not you, Miss W. Young. S. Young, unmute. Unmute. Hit the unmute button on your phone.
What are they doing? Unmute yourself.
The button is a microphone.
God have mercy.
Microphone.
Okay, sir.
Jason,
Everybody raise their right hand.
My right hand raised.
Right hand raised. All right. You swear or affirm to tell the truth, the whole truth, and the penalty of perjury of the law?
I do.
I do.
I do.
Mr. Lee?
Yes, I do.
All right. And again, Miss Young, W6 Young, you can mute. You are not an actual party. You can go ahead and mute. There you go. You guys can put your hands down.
Okay.
All right. Back again. Mr. Young, tell me, I've read everything. Tell me, do you have a lease with these folks?
I submitted the lease to them, and if they chose to stay, they could have stayed. If they didn't want to stay, they was supposed to leave.
Now, let me ask you this. These folks that you've identified, these folks that are here aren't those folks, except for maybe one or two. Why are their names different than the names that they've identified as their government names here on Zoom? Do you know, or is this the names that you know of them as?
Those are the names that I know them as. If they
Hold on, don't speak out of turn. Let one person speak at a time. So these members of your family, you didn't know their real names, like LJ Brightwell. Is that his real name, or is it
MJ,
It says LJ on the paper.
you talking about Laura's son?
I don't know Laura or her son. I'm
Laura
taking
Shihab.
the complaint.
That's Laura Shihab. Yeah, that's LJ Brightwell is her son.
Okay, and what about Don Quee Young?
Don Quaid told me that was his name, Don Quaid. So if it's his name is,
Well,
I
hold on,
really,
hold on,
if
hold
I
up, Mr.
misspelled it, yeah, I misspelled it. And
I
I'm
got
sorry,
it.
I didn't mean to misspell it.
Let me ask you this, man. I think we were here last time. You said you had the property. I can't recall exactly what happened. I know it was dismissed, but
You said I could resubmit it.
okay, everybody can resubmit. That's fine.
Yes.
So tell me, you don't have any rental amount as of yet. How much was the rental amount that you demanded with the new lease, and when?
It was $800.
Okay, and when did you provide them this new lease?
It's on the paperwork that I sent you, sir.
That's
Back in
not, I'm asking you a question.
2002, 2022. It was August. The last 2 months.
So when did you give them the lease? What month?
August and September.
You try to give it to them August and in September. Okay. And so you're alleging that they refused the lease in August, and therefore from that period of time, you're alleging that they would over it.
Yes, sir.
All right. And how did you come in possession of this property?
In my mom living trust, she awarded me. She gave me the property. Was some things that we had. I'm sorry.
I just to continue because as I understand trust, I'm just trying to make sure I understand things. So tell me. So she gave you the property.
Oh yes, sir.
Okay.
There was some things that was in the works for a number of years, and she had asked me to help her finish them. So I did, and in that process, I committed a large part of my investment money that I had to invest. She asked me, could I help her? And she said she had asked the rest of the family the same question, but they said no. So she asked me, and I was in a position to help her, and I did. And in doing so, she she awarded me the property because she couldn't pay me back the full amount of the property because the people that were staying in the house refused to pay her a monthly amount for her rent. So she called. She said, "Well, I can't continue to pay the loan off because the people in the house would not pay for staying there." So we just came out and said, "Well, okay, Mom, just we'll stop for now." So in that finality, she said that she gonna award me the house because she couldn't pay back the amount of money that she owed me. I said, "Okay, fine." And she said if she had passed away, to make sure that everybody got something in her passing. Now I said, I would do that, Mom. I would do that. Because she didn't think she had enough money on her life insurance to pay for her funeral arrangement, her final expenses, and to leave them each with some money. And that's what we did.
Okay, so when you say you were given this property, how are you given this property?
No, she gave the property to me. She awarded me with the property.
Okay, and when did she do that?
She's back in 2015.
I see a 1990 deed that you supplied, a quitclaim deed for 1990. I see another quitclaim deed that was filed in January of 2023.
Oh, I'm sorry.
Hold on, please don't speak up. This is okay. And this was October 1st. I'm just trying to see what document do you have here to establish this tenancy? Did you file that document? I mean, not this tenancy, the ownership. Because they don't have a lease with you. You said it was owned by your mother. You said you got it back in 2015. Did you file that document? Because everybody else is saying that you don't own the property and the property was not transferred to you back in 2015. So what do you have, the court evidence do you have to prove that you are in fact the owner?
You said you had asked me did I have some paperwork saying that I was the owner of the property and the delivering trust established that that I own the property. And
I need to see the paperwork. So what paperwork do you have to that?
I submitted that to your office, the judiciary office, and they said they was going to have it marked for you, the judge.
I got it. I'm looking at it. I do see this document here from 1990. I do not see any document here. Let me just see here. Hold on. Maybe I'm losing another one. Hold on, here it goes. Irrevocable Living Trust, 2015. The trustor and serving trustee, this trust shall be known as the Daisy May Young Irrevocable Trust. Schedule B. Is the address 3256 Stratton? Is that what you're talking about?
Right, 3256 Stratton Lane, Scottsdale, right.
Okay. All right. Hold on. And it says property will be brought out. It says property will be brought out by Tommy R. Young and paid to each family member a share of $1,300 and $2,000 each, depending on time of expiration of follows. Will be brought out. I see that there's several properties in here that you're identified as.
Yeah, the one's is a vacant lot, and the other properties has already been sold.
And I leave all the rest of the remainder of trust property administered by Loretta Young.
It's talking about like the living room suite, bedroom suites, and those kind of things. She's going to disperse that to those individuals.
I don't see any signature. Oh, let me see. Daisy Mae Young, Trust Store. "22nd day of 2015. Trust Store Trustee. I see Daisy Mae, but it doesn't. That's really weird. Why is it like that? All right, so I'm just trying to understand what part of this specifically are you saying? You're saying this one section here, Schedule B1, the 3256 Stratton Lane, Scottsdale, Georgia, property would be brought. It says brought out by Tommy R. Young and paid to each family member a share between 1,300. Have you done that? Did you pay those family members that money?
I've started on some of it, sir.
No. Well, hold on, wait, Ms. Hall. I'm just going. Have you done that?
The same individual that you keep interrupting is why I stopped it. It was stopped by some irregularities that occurred at the bank where I was dispersing the money to, and it was held up because of individuals that was in my family member. I think the one that was speaking out, if I could be, but that's the payment was being dispersed, but there was some irregularities happened because there was some fraud bought onto my account.
Let me ask you this. Do you have a deed transferring the property to you?
Oh, yes, I do.
Where's the deed?
I submitted that to you.
You got the deed. All right, let's see if there's a deed.
Let's see it.
Let's see a deed. Maybe I'm looking at it wrong. You do. So let me just make sure you understand. You do know that the trust is its own entity, correct?
Yeah.
And just because you're the trustee doesn't mean that you can do whatever that the trust is the one bringing it. You're just the person representing the trust.
And that I own the property as well.
It doesn't say that.
Yes, it does, sir. Yes, it does.
Hold on. I'm going to read this. Maybe I'm missing something. The only part of and I'm going to just post it. Hold on. Give me 1 second. I'm going to share my screen. Is this the document that you're referring to, sir?
Yes.
All right. And I'm going to read this part. And you're going to tell me where it says that you own the property. 3256 Stratton Lane, Scottsdale, Georgia, 30079 property will be brought out, assuming that's bought out.
Yes.
By Tommy R. Young and paid to each family member a share of $1,300 to $2,000 each, depending on time of expiration of the follows: Laura Young, Vicky Young, Linda Young, Evelyn Young, LaVarn Young, Loretta Young, Signy Young. If any party or parties declare that they do not wish to take a share, it does not have to, but will lose any ownership rights hereafter. So this was back in 2015. Have you paid these folks since 2015?
I was in the process of doing this, sir.
That's 8 years ago. That's yes or no?
I've done some part of yes.
Who have you paid?
Sydney Young, Linda Young.
Okay, Sydney and Linda.
And LaVarn.
And so you've still got 4 other folks that you would need to have paid.
Correct.
And why haven't they been paid?
Because we was trying to get the finalization as to what bill was still outstanding.
Of what is still outstanding?
If anything was still outstanding.
What do you mean still outstanding?
2015.
Where's your deed? So let me ask you this, because where's your deed transferring the property from the trust to you? Because this doesn't say that you don't have a deed. This isn't a deed.
I know.
So where's the deed?
I submitted that information with the same paperwork that this was in.
No, that's not here. I don't see that deed, not in this level of paperwork. Here, I'm going to go through the documents that you provided. This is the start of the trust. Now, again, if the trust still owns the property, sir, because I don't even see where this trust has been filed or anything of that nature. But
It's an irrevocable trust, sir. It doesn't have to be filed.
okay, I hear what you're saying, but what definitely needs to be filed is the deed. And so, to put people and everybody else in the world and the county on notice that you own it.
Yes, sir.
So, death of trustor. I leave in the upon of death of trustor, payment of trustors, debts, funeral expenses, expenses of illness, disbursement, listed articles, following distribution shall be made. Daisy Mae Young, state who has received property after termination of trust. I leave all the rest remainder of my trust property administered to Loretta Young. All right.
Say, Judge, on these documents, his last name is Tommy Young Jr., right?
I don't know yet, but hold on. Now, I see you say, I, Tommy R. Young, trustee of my mother's estate, hereby is representing her execution and now the owner of. I don't understand. How do you do that? Just because you're the trustee of the estate doesn't mean you immediately own the property.
But she awarded me the property, sir, in the trust.
But you have to have a deed. The trust is one thing, but that's why I think I remember. I feel like you don't understand how trusts work. The trust would need to give you a deed. First, the property would need to be transferred to the trust, because then the trust becomes an entity. It's like a person, right? And then that deed, that entity would transfer it to you, right?
Okay.
But I don't see that here. Show me where I have. Otherwise, the property is owned by the trust of Daisy Mae Young, and that would have been the party to file suit. So tell me where I have a deed, sir.
That deed document, I submitted it in that same paperwork, sir.
Okay, let's see if we find another. Hold tight. Could have overlooked. I'm gonna stop sharing for a second, because I recall that was the issue prior. We didn't have any proof.
So you asked me for the deed book and page number.
I understand. Did you submit that same deed that I looked up a month ago with the documents that you filed this time?
Sir?
This is your case. You got to provide the court with the evidence. I'm asking you, where is your... Here, I'm going to open this back up. Hold tight. And I'm not trying to be difficult with you, but I've explained this to you last time, and I just want to make sure we're not running our wheels around.
Right.
This is the second amount of documents that you provided the court. All right. That's the month-to-month rental agreement that you provided. And you provided that solely to Sydney Young. You didn't provide that to any of the other parties that I look here at.
I did.
You did? There's other ones. So I see Sydney Young as an individual. And this is L.J. Brightwell. Laura... And then Don Q. Young. Okay. And this was back on Let's see. This was back in 2022. So this is before we had our second case. This is the quick claim deed that you're referring to?
Yes, sir.
When'd your mom pass?
15 and 15.
So how is she transferring it to you?
No, she did. She passed
2022.
back in 2022.
So when'd your mom pass, Tommy, Mr. Young?
It was in 15.
Okay.
No, she did. She passed.
Wait, hold on. I'm just gonna hear what he has to say first, sir. Don't worry. It's all right. So I'm looking at this quick claim deed. Tommy R. Young, right? Property transfer tax that you didn't pay. Assessor parcel. Date of preparation, December 29th. Quick claim deed. Grantors. Grantees. Who's Esther R. Young?
She's my wife.
So how are you granting it to yourself if you already own it? Do you understand my issue?
No.
No?
Say that again, sir.
All right. When'd your mother pass away? Why didn't she sign for it? Why didn't the trust sign it?
Oh, okay. Okay. You said this. I'm sorry. Okay. Okay.
If
I
you
missed.
filed this act, listen, you filed this action in February. All right? Right? Are you saying the document that I'm asking for, she says she sold it back to you back in 15. This document is dated for 2022. When'd your mother pass?
In 15.
So how is she transferring it to you in 2022?
Oh, okay. Okay.
No, answer my question. Don't tell me okay.
Well, in the trust, it's dated when she signed it. In 15. And in the trust.
Well, there was a condition in the trust that you were supposed to do something before that even could potentially be done. And it doesn't seem like you've done it. And if you didn't own the property before she passed, it may be in the trust, because that may not need to be probated. But at the same time, the trust didn't actually transfer you the property.
Oh.
You see what I'm saying? It said
okay.
You will get the property, but you have to do this consideration to pay other folks out. But even then, the trust never gave you a deed. So I think what you're saying is this acts as a will, that when you pass, I'm gonna get this property, right? But this isn't a will. This is an irrevocable trust.
Correct.
So if she passed with the will, what she would have done is you would have probated that will, and it would have specifically said you got that property, and you would have got the property, right?
In the trust, it said that I get the property.
No, it don't say that in the trust. It don't just say that. We brought it up. What it effectively says is you buy out the property. She's gonna allow you to buy it out, and in buying it out, you're to compensate these other folks to buy out their interest
at the price that we stated.
But you didn't buy them out before she passed.
It didn't say that to buy them out. It said after she passed, sir.
Okay.
It said after she passed.
But this is the problem. Even if that's the case, now you're gonna have to get that probated because you haven't done all those things.
But the trust don't have to be probated. It says that specifically.
But the property, you're saying this is the other issue that I don't think you get. You still need to take the property and put it in the trust.
Okay.
Wait. Let me hear it again. You still need to take the property and put it in the trust.
Okay.
So I'm giving you free information. The trust is created.
Yes.
It's there.
Okay.
But ain't nothing in it unless it's put in it.
Okay.
Because Daisy May ain't the trust.
Okay.
So everything that Daisy wants to give to the trust so that she can then allow you as the trustee to do it, they're going to have to transfer to the trust.
Okay.
So what I want to ask you is, when did Daisy May transfer the property from her to the Daisy May Trust?
The day she signed it.
Do you have a deed transferring the property from Daisy May to the Daisy May Trust?
The deed, the verbiage is in there.
You're not. Why are you playing with me, man?
I'm
Do
not
I look
playing.
like somebody? Do I look like somebody who just does this and I just got up one day and said I'm gonna put on this robe?
No, okay. So
So don't listen. If I ask you a real question, I want a real answer. You're trying to evict folk. I'm spending my time, and you clearly haven't done what you're supposed to do. This is your
Okay.
second time coming to me, and I've asked these same questions of you. And
Okay.
you give me a deed that clearly has been drafted after your mother has passed that neither identifies her, the trust, right? So I'm trying to figure out where your authority comes from. Because it doesn't seem like it's there.
okay.
So if I don't see a deed from her to the trust, then the trust doesn't own it. If I don't see a deed from you with her signature on it, or at least the trust signature on it, then it's not there. You're saying because you're the trustee that now you can unilaterally transfer this property into her name, but the trust doesn't own it yet because the trust hasn't actually done its job of putting the property in the trust. But now she's passed. And so now, if the property's not in the trust, that might have to be a probated property, which means that you wouldn't own it. Now, you could have your own arguments of why you should and maybe produce this trust agreement. But at this juncture, I just don't see where you have that basis.
Okay. The trust, the house need to be in the trust.
And I'm going to be honest. I'm not trying to be difficult with you. I mean, listen here, people. My interest is not to bash or anybody, but I don't want you to waste the court's time trying to do something that you think that you can do.
Okay.
What I'm saying to you is this, just so you know. So this is basic stuff.
Okay.
Let's say, for instance, you own a property, a trust, and you want the trust to have it. So if you die, your family can enjoy it forever, right? The
Okay.
problem is you still own it because the trust is now a new entity. So now the new entity has to get the property before the trust can do anything else with it, because you are not the trust. You understand? Your name is on the trust. You can name your trust 1, 2, 3, 4, 5 trust, right?
Yes.
Just because it says Daisy May don't mean that everything Daisy May owns is automatically in the trust.
Okay.
Now, she's also trying to do this somewhat as a will, because I see how she's trying to assign other things, and that's fine. So this is almost like a will, kind of, sort of. But even that would have to be probated. But if you wanted the property to automatically be in the trust, it would have had to already be in the trust. There would have been a deed saying Daisy May transfers this property to the Daisy May Trust. It could have been a quitclaim deed. And then she could have the trust could do whatever they wanted to with that property. But I don't see any documentation of that. I see a quitclaim deed well after the fact. Now you're going to say, well, Your Honor, I'm the trustee. I can transfer that but you can only transfer what you have authority to transfer. And if the property is not in the trust, then you have no authority over that property as the trustee. Does that make sense to you?
Kind of, but not clearly.
I can see why it wouldn't, because that means you wouldn't get what you wanted. But I'm going to tell you that for this evening, I still have not seen where you've established that you're the appropriate owner to have a landlord-tenant relationship to pursue this action. I've seen a deed that has been filed just 2 months ago, or really a month ago, for a trust that doesn't seem to have any direct, clear ownership of the property. And so I would just tell you, Mr. Young, again, I'm not your attorney, but I'm saying until I can have some clarity here that the trust owned it, and even then, sir, you would have needed to have that document filed, and it would have been, the pursuit of this case would have been in your name or the Daisy May Trust. So it's like one or two things. Either you own it, and you had to pursue it in the name of the Daisy, and you can pursue it in your name, but then I just need a deed from Daisy May Trust to you. Or I need this case to be in the name of Daisy May Trust, but then I'm going to ask, well, Daisy May Trust, when did you get the property? And if neither one of those things are established, then ownership of this property is in the air. So I'm going to dismiss the case in all due respect. But I'm going to hear from the other parties first. before I make my final order.
Before you go, can I ask a couple questions again?
What, to a degree, again, what I tell you is one thing, but what you can ask, let's see if I can tell you something.
Okay, you said the house need to be in the trust.
Well, it's depending upon how the facts look. But I can't tell you exactly what needs to be in order to execute what you want to have happen. But I'm just saying, if the house was, you're saying that you're the trustee, and the house is owned by the trust, then I would need to have proof that the trust owns the property.
Okay.
But anyway, let me hear from the other parties here. I'm going to start with Mr. Lee.
I just want to know, like, can anyone evict anyone if they don't have proof of?
Anyone can file what everybody wants to file, but that don't mean they're going to get the results that they so desire.
Okay, that's all. That's kind of what I want to know, because he's basically trying to evict someone that he doesn't have proof of the property, though.
And again, until the court hears it, we don't know until we hear the case. So we can't stop people from doing things until we hear it.
Yes. And however, I want to know if he has, like the right evidence or the right documentation. Why hasn't he had presented to the family, though? You know what I mean?
That is not a question for me to answer. That is between the family. All right. All right. Miss Hart, anything else? All right, Miss Hart.
Thank you so much, Judge. Judge, thank you for taking this time again. I'm sorry that this is happening to us as well as you. Is there any way you can rule that he cannot file any more papers on this case in terms of eviction? Because he has no proof. He's wasting our time. I have already filed papers, letter of administration, to become the administrator. There's 8 siblings. 4 agreed, 4 has not agreed. And all I'm trying to do is get it probated.
I got it. And so let me tell you, because of that, and I don't know what the Superior Court would do. I don't know how all the documents would look. I definitely cannot dismiss the case with prejudice because I'm not sure how things may shake out. But as of for today, because the evidence doesn't support the request that he is making, I'm dismissing the case. I can't make a decision on something that hasn't necessarily happened yet. You're still on mute.
Sorry, I put myself in. One quick thing. So with him, okay, is he able to continue to file papers on this irrevocable trust about the house being in it when you know it's not in it, knowing that it should be probated?
Again, I can't comment on because I can't say what he will do. And
okay,
I don't know what he will present. I can just look at what's in front of me, and the documentation that he has provided does not provide clear evidence that there is a landlord-tenant relationship between the parties. And as a result, that case is going to need to be dismissed. And so, Mr. Young, as you proceed, it is up to you how you proceed. But again, the court is identifying or dealing with these cases on an individual basis, and the information that you provided does not support the relief that you're seeking. So I'm going to dismiss the case, and you guys are free to go for this evening. You have a blessed one.
Thank you. Thank you, Judge.
All right. And with that will address all the cases on the 2/23/2023 landlord tenant dispossessory calendar. You can end live recording.